touching on what is going on with our deputy presidency. We saw one that was removed through a political process through the houses, and now the battle is in the justice corridors. The big question is, what is going on there? A case after the other. Actually an empowerment of a bench that was put together, but a team says that the way the bench was constituted was not done right, so we need to do away with this bench. It's a lot of legal drama, suiting what ideally, if you're a movie watcher, we call suits. But to bring us to that, to understand today what is the hurdle that we are facing and we're watching on our screens, touching on Gachagua's impeachment, I'd like to bring in our very own reporter, Fred Kagonye, who's at the Milimani Law Courts. Good afternoon, Fred. Just help us understand in the simplest of language, what is going on today in court?
Thank you very much. We are coming to you live at the Milimani High Court, where the Rigathi bench is supposed to deliver a ruling on the panel. So the judges basically they're coming to tell the petitioner and the rest whether they are fit to have sitting and listen to these cases without challenging the impeachment of the deputy president Rigathi Gachagua. So in simple words, there's a person coming to tell you whether they are fit to hear your side of the story and hear the other side of the story. Basically, that's all.
This seems the sound, I don't know whether it's my sound here, but what I'm getting from you is the decision in regards to whether this particular panel of judges was constituted in a legal way, in a proper way or not. And since it is a legal thing that is ongoing, and it seems to be one of those aspects that are shaping whether Gachagua's ousting from the deputy president office is done in a clean-cut manner or not, I'd like to welcome our wonderful constitutional lawyer and also a law scholar, Dr. Eric Omolo, joins us this afternoon. Dr. Ari, thank you very much for making time. I mean, is this, first of all, just help us understand, because there seems to be a number of cases that are going on in parallel, almost at the same time. Where are we in this whole process? Bring us up to date in the simplest of languages.
Thank you very much. What really happened is that when the impeachment process commenced a couple of weeks ago, many people, whether coordinated or uncoordinated, attempted to stop it first at the National Assembly and then at the Senate level. And that meant that several cases were filed primarily over the same subject matter. So at a particular point, a decision was made to consolidate them, and the Chief Justice appointed these three judge bench that is that we're about to get a ruling from them today. The issue that is coming up today is whether, in terms of the conservatory orders that were issued last week, whether the Chief Justice herself did appoint this particular bench to then hear the petitions that relate to the conservatory orders. The petitions basically were those now challenging the process that happened at the Senate, and importantly, that then basically stop the process in the sense that no action should be taken based on the resolution of the Senate. So it's a bit of a dicey situation because there was already a three-judge bench, but these orders were issued on Friday, and logistically it looks like the Chief Justice did not appoint this three-judge bench specifically for these cases that were filed last Friday. So the main argument here is that the job of constituting a panel of an even number of judges is primarily a job of the Chief Justice and not the Deputy Chief Justice. So we'll see. There's a lot of precedent that points to the fact that the Deputy Chief Justice has powers of the Chief Justice in absence, but that is not the argument that is being advanced by the lawyers for Mr. Gachagua. And I do not know the real background why they are making this particular application, but it could be that they do not have confidence in some of the judges. And importantly, they could also be thinking that the orders that were issued to move the hearing of the application to lift the conservatory orders were issued out of time by these same judges, I think, that moved the hearing from 24th back to 22nd, which was yesterday. So I think those raised a bit of suspicion, and that is why we are where we are.
All right. Dr. Now, it is supposed to go both ways, in many ways. For starters, you're saying that it is the Chief Justice's power within her purview to appoint this panel of judges, and that didn't happen. But again, there are legal pockets in there to sort of give the DCJ an opportunity to do so. So let's create a scenario here. If at all it is found that it is possible that the DCJ actually had the power to constitute this, how do we perceive that? How does the case move forward from that? And if otherwise, again, how do we move forward from these two scenarios?
A constitutional question that I don't think is before this particular bench, led by Justice Eric Ogola and of course Justice Murima and Justice Freda Mugambi. The big constitutional question that I think it's a big constitutional question that I think should be handled at a different level in a different petition. In particular, what powers can be delegated by Chief Justice to her deputy? Can she delegate judicial powers or administrative powers? And what there does the Constitution anticipate to be the role of the Deputy Chief Justice in the absence of the Chief Justice? And that is almost similar to the case of what can a president do, what can a deputy president do in the absence of a president. It's different when the president is dead or has resigned. It's a different thing when the president is just out of station, as the Chief Justice was. So I think this is a serious constitutional matter that should not probably be dealt with by this bench, but that needs a bit of finality at the right time. At the moment, it seems to me to be a pure question whether the judges deem themselves to have been properly empaneled for purposes of the petitions that were filed last Friday, and the petitions were post-Senate's resolution, resolution of the National Assembly, passing Professor Kindiki as quote-unquote deputy president-elect. So this administratively seems to not have been handled in a manner that satisfies Mr. Gachagua's team. And so in a regular court practice, this will be a pure question where the judges say, and in any case, I think the Chief Justice can clear it very well, where it is clear that the Chief Justice did appoint them. And if that did not happen, then I think in the interest of time and national interest based on the issues at hand, that it may make sense that this is one of those that is returned to the Chief Justice to empanel a fresh bench to handle so that it is done expeditiously and in the interest of the country, because we do need to have some certainty in terms of who's the deputy president. From where I stand, I think it is still Mr. Gachagua, but we do need some certainty. And importantly, we also do need some finality based on at what level does the impeachment end. And then either we retain Mr. Gachagua or Professor Kindiki comes in. Because look, in many ways, the president is handicapped now, because from what I listen, his team is saying he doesn't have a deputy. But from different lawyers arguing for different sides, either of the two is deputy. One is elect, another is substantive or impeached. So you can see this is not a very comfortable position to be in, which is why we do need a decision of the High Court that is properly empaneled, that probably has the confidence of everyone to do this within a week or so.
Dr. It's quite interesting. You say that from where you sit, Gachagua is still the deputy president. I know you've alluded to the fact that there's an argument from different facets and different points of views, legally speaking. Why do you hold that opinion before we cross over to Milimani law courts?
Look, the import of conservatory orders, which are issued by courts from time to time, is to maintain the status quo until the issue in dispute is resolved. And so, for example, in typical labor disputes, if somebody is about to be sacked, because the sacking it comes in stages, and then they obtain an order stopping the process or stopping implementation of the effects of the process, then logically, purely logically, that person remains in office. As to whether they have the instruments to exercise powers of the office is a different thing, which of course Mr. Gachagua does not have. But if it were to be a logical interpretation of the Constitution, then he remains the deputy president. So his circumstances have significantly changed. The ground has shifted a lot. But in case something were to, God forbid, happen to the president, then I think everyone will be hard-pressed to try to justify that Mr. Kindiki, with these conservatory orders, is the deputy president, let alone the fact that he has not been sworn in.
Okay.
But I think we go back to the bigger point. This is one of those situations where we do need a determination of the High Court, and I think it will go to the Court of Appeal and Supreme Court, and we need it to be expeditious. And if the dispute is about empaneling of these judges and circumstances that they were empaneled, because I do know them and I think they are very professional people, then it makes sense that this goes back to the Chief Justice to empanel immediately, which he can do today, and we have these matters heard as soon as possible, preferably next week.
Definitely. And there is actually element of which is very interesting, because it is sort of a precedent that was set from Parliament in terms of how quick this process has been. And you say that there is that element of we don't know where the deputy president position lies and is of public interest. And it raises that question. What is the public interest in this case? Why should Kenyans be paying attention to this particular process? How critical is it, especially in moving forward, how we handle that balance between the way we do politics and now legislature and now judiciary has been involved in this whole process?
So first, let's remove National Assembly and Senate from this. In law, we say they have done their job, they are functus officio. Whether they did it right or not is one of the very important questions to be determined by our courts going forward. But look, the deputy president is not really a private citizen. The president is not really a private citizen. They are public property, and they exercise constitutional mandate that the people of Kenya saw fit to define in terms of even when they assume office, how they assume office and how they leave office, and how they're taken care of throughout. In fact, we also, if we were a more transparent country, we should also be knowing status of their health on annual basis. So the public interest is derived from the functional role of that office and how it is important in conducting both domestic and international affairs of the country. As I speak to you, many heads of state are meeting in Apia, Samoa, Commonwealth. President Ruto is not there. He sent the Foreign Affairs Minister. Several heads of state are meeting somewhere in Kazan in Russia. BRICS, you know, BRICS is coming as a serious bloc for emerging economies. These are places where ordinarily Kenya should be represented at the highest level. None is happening because the president has to deal with domestic issues. If we had a situation where the deputies in place one with the other, then you can see that one of them would at the very least attend one of these summits, for the simple reason that these are very important global summits for conducting Kenya's foreign affairs, let alone the fact that we want one of our own to head the African Union. So public interests that comes with these offices override individual interests that obviously the president, the deputy, and the people around them may have, which of course, it is not always the case that they are in consonance. I mean, private interests normally conflict public interests. But I think several Kenyans, the ones I know are paying attention to this and are concerned that this seems to be dragging in for so long, are concerned that perhaps the processes may have not been followed to the letter. And the only thing that I think is making all of us happy, particularly as lawyers, that the Constitution is being tested the way we had envisaged, and that the Constitution seems to be working to the extent that we know that from one stage it moves to the other, from the National Assembly it moves to the Senate, and then it comes here to the High Court, up to the Court of Appeal. And so in a way, we are better than many other African countries because this is a more predictable process, it's a more civil process, and importantly, I think it's also setting a jurisprudence that will guide the country going forward. I don't think this is the last impeachment of either the president or deputy that we will have, just because of how polarized our politics is. But either way, I think you and I agree that one way or the other, we need to have finality to the process. It should not drag on for far too long. And I think the trajectory we are taking is that this is dragging on for far too long.
Definitely. I'm glad you've mentioned that we are stretching our constitution. And I mean, being the first fruit of being tested, like the likes of Gachagua, being the first one to be impeached, Deputy President, you've said that jurisprudence it's very, very important. I mean, now we are seeing this at a national scale. When it comes to impeachment, we've seen even at the county levels, because those are our units that we got from our 2010 constitution. How do you see this as an affirmation of what has been going on in the county, and moving forward, this will be sort of a norm if you're not playing ball, either according to the people or the powers that be, you are easily impeached?
You know, it's also important to note that of all impeachments that have gone in the county assembly and finally ended up in the Senate, only two seem to have succeeded, that of Waititu and Sonko. I think that there's obvious weakness in the laws governing counties that allow MCS to normally bring what look like frivolous allegations, what look like conflicts over contracts and budget, to the national level, and from time to time, counties end up wasting a lot of money paying lawyers and obviously paying, covering the cost of impeachment. But that of president and deputy president is in the Constitution. It's a national thing. Counties, those are normal local squabbles that are resolved one way or the other. And so when we are dealing with this of the deputy and the president, you may say it is a bit of special, it's a bit of sui generis in a way, and that is why everyone is paying attention. Look, I don't hold brief for Mr. Gachagua, I don't hold brief for the president, I don't hold brief for National Assembly or Senate, I hold brief for the Constitution and the people of Kenya for that matter in terms of public interest. And I think that when you are doing the very import of impeachment, that it should be the sword of last resort, the kind of tool of last resort. And so for it to have reached, because Mr. Gachagua and the president are generally reasonable people, for it to have reached where it is, there must be some underlying differences that initially they were not telling us. Initially, I don't think the 11 grounds covered them. But finally, when Mr. Gachagua left hospital on, I think that was on Monday, then he started talking to things that none of us knew, which pointed to a relationship that has broken down, perhaps irretrievably. And so I think that we need to interrogate a situation where is it the personal differences or the constitutional threshold that you and I agree on that should be ground for impeachment. And I think none of us has that answer. And that is one of the things, one of the questions that is coming up in the High Court. What is the threshold that you use to impeach a president, that you use to impeach a deputy president? Is it true that when you vote for a president in a presidential election, you are voting for both, or the president has discretion to choose his, despite the president having discretion to choose his running mate, he also has some kind of discretion to do away with him when he won. So that's a question Mr. Gachagua has been advancing, that I think will also be interrogated by the courts, and of course the courts will determine, and I think that will guide the threshold whether that election is for both of them, and to that extent, impeachment should not be seen to overturn the will of the people, take it in quotes. Another one that I think the court, in terms of establishing jurisprudence, the court will have to look at is the bigger question of what is the process that you follow before you initiate impeachment process. For example, there are allegations of money laundering, there are allegations of bullying, there are allegations of interfering with the judiciary and all that. And the judiciary has its own mechanism of processing allegations against judges. We all know that through Judicial Service Commission. So do you wait for the Judicial Service Commission to determine if you say somebody is corrupt? Do you wait for ESCC to successfully prosecute them? Or you can use that allegation to do impeachment, which many say is a political process. I tend to think that this is one of those things that require very reasonable, very emotionally intelligent balance. I do not have an answer, but I think that at the end of the day, we need to set a precedent that is more predictable, that is not prone to abuse, and I think that is what Mr. Gachagua is saying, that this process has been abused. Okay. The contrary view is also true from the other side. So nobody really has an answer, my friend.
Definitely. I mean, and this one, because the process when it began, this impeachment process, it was, branded, it's a political process. Now it is a legal process. Do you think the ripple effect of what we are seeing right now in our legal space and the whole process that this impeachment motion has been going through, do you think it is having a ripple effect on how we will do our politics, especially that presidency and deputy presidency engagement? Is there room for changes, even constitutional amendments in this regard?
I have never bought the idea that we need to amend the Constitution of Kenya except to empower devolved units, perhaps move them to ward level and increase checks and balances within the devolved units, and also to empower the Senate. I've always thought that the Senate needs to do what it is doing now, be an intra-institution, within the institution check of the National Assembly in terms of every bill coming from the National Assembly going to the Senate, as is the case in many jurisdictions. I think the often cited one is the United States. Other than that, I think our Constitution is working. I think that this impeachment process itself is showing us that the Constitution is working, that despite their imperfections, in terms of our institutional imperfections, when called upon, institutions can actually do their job. But we all agree that we do have a weak link in the political system, particularly the National Assembly and the Senate, partly because we are in a party-based system where MPs are elected in the party of either the president or the opposition, and therefore they are whipped. And obviously, we are in a country that also ranks very high on many indices of corruption. And I don't think the political class is immune to be more diplomatic to them. So the factors that make our institutions not work have nothing to do with the Constitution. They have everything to do with our body politics, our value system, our ethics. And those are things that we should be changing through auditing the process and holding individuals to account, including, by the way, the deputy president. Impeachment is a way of holding him to account. When he was talking of shareholders, he has to tell. Now he's telling us what he meant. But the reality is that we are also in a tribal country. So I do not want to go the route of trying to even imagine amending the Constitution. I want our institutions, and I think that's what every citizen wants, every right-thinking lawyer wants, to be held to account by first being allowed to do their job, including being resourced, including now in the case of the judiciary, being given sufficient resources to do their job. And if individuals within the system don't do their job, or are divisive, as Mr. Gachagua is alleged to be, or have vendetta, as some on the government side are saying, to have against Mr. Gachagua, whatever it is, I'm just repeating what others are saying in the public knowledge, then those individuals are held to account, not seeing the route of constitutional amendment as they did try to do in BBI, which was not a bad thing except for a few aspects, and which failed and polarized the country. So look, we have a perfect, near perfect constitution.
All right. Right now we are back at the Milimani Law Courts, and let's see whether this particular three-judge bench was put together, which was put together by the DCJ, Philomena Mulu, was properly constituted or not. That's the big question this afternoon, all the way back to Milimani Law Court.
May it please you, my Lord. My name is Shadrach Moset, Solicitor General. Appearing together with Professor Gitumo Yigai, Senior Counsel. That's for the Attorney General. Emmanuel Peter, Deputy Chief State Counsel. Charles Mutinda, Deputy Chief State Counsel. Then for the National Assembly, we have Elk Gumbo, appearing for the National Assembly, and Paul Nyamodi, and the Honorable George Gitonga Murugara. My lords and my lady, for the Speaker of the National Assembly, we have Benson Milimo and Josephat Kunyoni appearing for the Speaker of the National Assembly. My lords and my lady, for the Senate, we have Professor Tom Ochenda and Moni Mukele Edwin. For the Speaker of the Senate, my lords and my lady, we have Mercy Tanchi and Peter Wanyama appearing for the Senate, for the Speaker of the Senate. And for interested parties, my lord, we have Moses Kipkoge, we have Dr. Mutomi Tionkoru, we have Kenny Meli, and we have Ponfes Mwelelu and Eric Murioki appearing for Professor Kitule Kindiki. Sorry, my lord, for the Senate, we have Honorable Hirali Sigay for the Senate.
In addition to Professor Tom Ochienda?
Yes, that is in addition, my lord, to Professor Tom Ochienda.
Hillary who?
Sigay. Honorable Hillary Sigay, Senate.
My lord, Valerie, I'm present.
My lord, for the sixth respondent, much obliged, my lord. I leave it at that.
Thank you. My lord, for the sixth respondent, Dr. Kamodo, we continue to appear at a protest.
Kimoto Teresia Wanjiru, Judge Kimoto and Company Advocate for the second petitioner.